And again, Mark Jensen gets another shot. Very rare for somebody in his position to get another bite at the apple. This time, of course, he is looking for his freedom. Joining us now to talk about it in studio, criminal defense attorney Josh Schiffer, and in Sarasota, Florida, federal trial attorney and litigator Alexis Rosenberg. Good morning to both of you. Alexis, to you first on this. Without the letter, there's not a ton of physical evidence that, you got the internet searches here, but the case is more difficult, and inherently trying a case years afterwards, you've got dead witnesses, people that have lost their memory, they just don't recall at the same levels. This is going to be a much heavier lift, is it not, for the state of Wisconsin?
Ted, you're absolutely right. We're talking 25 years later, which is a very long time. We do have some primary witnesses that are no longer here, or not going to be able to testify. I mean, he's not going to win Husband of the Year, that is for sure. But the question is whether the state is going to be able to prove what they need to prove in this case. And with the, historically, when you have that gap, it does make it harder, and it's going to be a harder case to try. And not having that letter as well, that's a big thing, because it was her speaking from the grave.
Yeah, absolutely. I mean, this letter, if anything happens to me, he would be my first suspect. He being my husband. A jury reads that, which the first jury did, Josh. The second jury will not. Yeah, of course you're going to be like, ooh, he did it.
I think it's the dispositive evidence, just like Alexis is talking about. This letter is so important to establish the motive. Without that letter, the state, like you talk about, doesn't have a lot of paddles in the water. They can't put it all together, even though there's a lot of smoke out there, considering the relationship Mr. Jensen had afterwards. There's a lot there that would raise your suspicions, but I think that letter very clearly put the jury over the edge with a conviction, and now we'll see if the state can carry that burden again.
The letter is so important to the state, and that played out during the first trial. Judge Schrader, who we all remember from Kyle Rittenhouse, he was the judge in the first time around, and he said, no, letter's not coming in. I'm not going to deal with this. This is, you're talking about the confrontation clause. The state, after his ruling that the letter's not coming in, said, oh, we need it. So they go up to a higher court. The higher court says, Schrader, you're pulling that letter in. And now he, of course, he made the right decision at the time, but you wouldn't go, Alexis, to that next level unless you really wanted it, if you're the prosecution. And inherently, you felt like you needed it, because it was a risk at that time. They knew this could possibly come back to bite them.
I mean, I agree. This prosecutor is interesting because he seems very, very vested. I mean, prosecutors get vested in their cases, but he seems overly invested in this particular case. He wanted that letter in. He knew at the time he needed that letter. But he also, prosecutors need to take into consideration, is it going to stick? Because, retrying this case along with the appeal is very costly for the state. And, it also doesn't bring much closure, the ongoing, for the family as well. So he may have been very short-sighted to be able to do what he did instead of trying to try the case without it to start with.
Here's Judge Schrader talking about the first time around and his decision, which was reversed. Take a listen.
I tried the case according to the way the Supreme Court told me to try it. And that was 20 years ago. The man is still in prison, and the case has again been reversed because of the evidence that the Supreme Court told me to admit. I don't want to mess around with confrontation issues.
Josh, confrontation, for people that don't understand, well, they should see the letter, right? The jury's got to decide the guy's fate. They should see the letter. What's the problem?
Yeah, no, this is really core constitutional stuff. This is fundamental. It's why judges being so deferential, because it's the third rail. If you screw up confrontation issues, the trial's invalid, and the confrontation issue goes back to your right as a citizen to confront and be confronted by the people accusing you of the crime, specifically your ability to cross-examine and thoroughly investigate any and all evidence being brought against you. And he doesn't have the opportunity to cross-examine his wife.
Because he killed her.
Well, yes, but at the same time, there's fundamental fairness issues, and the state has a burden to prove him guilty beyond a reasonable doubt with the admissible evidence. That's what's important, and the judge did a great job trying to follow the instructions. He's going to do it again.
It was worked in because there was enough evidence, according to the state Supreme Court at the time, that he did kill her. You lose that right, do you not? If you're the cause of the fact that you can't confront Alexis.
No, the Constitution is the Constitution, and that is what our legal system is built on. We can't carve out special exceptions because we think someone is guilty. I mean, that's the reason we have the Constitution, so that we have to prove beyond a reasonable doubt. You have to have the right to confront someone. So, I mean, the Supreme Court, you know, the court shouldn't have made that ruling, and the initial judge was correct.
Unfortunately, the original judge, Judge Schrader, is not presiding. I'm sure the judge who is great, but we love Judge Schrader. He is not presiding on the retrial here. Let's take a look at the jury makeup. All right, the judge reading the preliminary jury instructions before the opening statements. It's got, you know, kind of a thick packet there, relatively, and this is, we see this in each of our live trials. Let's talk a little bit about what is ahead with Josh Schiffer and Alexis Rosenberg. Alexis, all the work that's gone in, now you've done it, you're getting ready for your opening. What's this moment like as you're listening to the judge drone on about with the instructions and your last minute thoughts on it was something you've been looking forward to in a lot of cases, months and sometimes years?
I mean, prepping for a trial is exhausting. I mean, it's not just the trial. There's a lot, like you said, Ted, a lot of preparation that goes into getting to that moment. I mean, these instructions are being read for the jury. As attorneys, we've heard them so many times that sometimes we've got them memorized and we could just do them. So you're not really paying attention really specifically at this point as to what the judge is saying, because it's really for the jury. So you're kind of going through your game plan, just continuing to organize things in your head. But it really is like stepping up to a plate, you know, in baseball when you're getting ready. So the adrenaline is going at this point.
The adrenaline is everywhere. You can see the defendant. This is his opportunity to check out the jury, because in about 10, 15 minutes from now, jurors are going to be comfortable, and then they're going to be checking him out for days and weeks and weeks. But right now, they're like first-day students, and they're staring at the judge, soaking in all of this, or trying to. But it's interesting to watch him. He's like, okay, juror number 7 looks good. This is it's like a pregame of a huge game, you know, like a football game or something. This is that moment where when you're in the courtroom, you just feel the anticipation.
Absolutely. This is the pregame. The judge is doing the MC work, you know. And now, ladies and gentlemen, about to come on the stage is the amazing. That's what you're doing. And just like Alexis is talking about, we've heard this 50 million times as a lawyer. We're not listening to the judge as much as we're getting into our zone, because when the judge is done, this thing goes live. And it is absolutely live, in living color. There is no second tapes. There's no pause it, go back to the production team. No, whatever happens, happens. That includes what the defendant's doing. And like you note, the jury's staring at him as much as he's staring at the jury. And impressions matter. It's those little things we always talk about in trial skills, where if your defendant is acting in a way inadvertent or intentionally that offends or benefits him, that's where this stuff starts to really count. And it's exciting. Everyone's heart's pumping, that's for sure.
Alexis, if you're the state, what's your theme here?
I mean, the theme is what the initial theme was. I mean, they believe that he killed his wife to be with the mistress. And I mean, based on the facts, there's a strong case for that. I mean, he ultimately married that mistress. And so, I mean, they're divorced now. So that's going to be interesting when she gets up on the stand at this point. But I mean, the theme is he killed the wife to be with that other woman. The oldest theme in history.
It sure is, and a motive that doesn't take a lot to articulate for a jury to understand. What about the defense? What are you going to be listening for here as we watch the opening statement on Mark Jensen's behalf?
That the state doesn't have the motive that they focused on so much in the first trial. Now, that's important to think about how the state's going to present their case to a brand new jury that theoretically doesn't know anything about the prior trial or this letter. They hopefully are pure and clean for all intents and purposes right now. So the state's going to make a choice with what their theme is, like Alexis is talking about. There's kind of that where there's smoke, there's fire. We don't have the evidence we really wanted, but we still have all these other pieces of evidence, and the totality of the circumstances makes it so that no one else was going to go murder this woman. And clearly, he had a lot of reasons to do so. The question now is whether the state can carry that burden while lacking the letter. And if they can, good for them. But it's a lot more difficult, especially with the time, the dulled witness memories, the divorce, what new testimony is going to come out. This is going to be fascinating.
Many people think openings are very important. Others say, not so much. It's kind of just a roadmap. The evidence will show, blah, blah, blah. And in a couple days, people forget. How important do you think these next moments are for both sides, Alexis?
I mean, I'm of the camp that if done correctly, openings are very important because it kind of just gives the jury, like you said, the roadmap, and it puts them on the road that you're hoping that they're going to ultimately end up at the destination of either acquittal or a conviction, depending on what camp you're in. So I believe that it is very, very important if done correctly. I think a lot of times it's not done correctly and it comes out like you are. You're going to hear this, you're going to hear that, and not really instilling the the elements that you need to instill to get the ultimate outcome that whatever side you're on, you're trying to achieve.
Both sides have 90 minutes. We've been told that both sides intend to use their 90 minutes. Is that too long, Josh?
I've got a lot of questions about lengthy statements because I'm spending time in front of juries. They have a limited attention span. They're ready to go to work. They've already been through voir dire. They're selected. They're on this jury. They generally want to take care of business. They want to hear about it.
And so do we.
Exactly.
Let's get a break in here before they start. The jury instructions still being read as the defendant waits to find out his fate. It's going to take a few weeks. We're expecting the trial to go for maybe 6 weeks.